Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Hello, and welcome to our podcast about ESG issues. My name is Terry Johnson. I'm a corporate partner in the San Francisco office of Arnold & Porter. I'm one of the co-heads of the firm's ESG group and one of the co-editors of the book that we published through the ABA, Environmental Social Governance, The Professional's Guide to the Law and Practice of ESG. I'm here with a couple of my colleagues, Eric Walsh and Arthur Luke, to talk about ESG issues in the current time.
Hello, I'm Mr. Eric Walsh. I am a counsel in the Financial Services Group in Arnold & Porter's New York office. I primarily represent banks and other financial institutions in government investigations and on regulatory matters, including these days quite a bit on ESG-related matters.
Hello, I'm Arthur Luke, a partner in Arnold & Porter's Securities Enforcement and Litigation Practice, based in our Washington, D.C. office. I advise companies, boards, individual officers, and directors in responding to SEC investigations, shareholder demands, and securities litigation, including how to work through ESG-related issues.
Thank you. It's great to be with everyone today virtually. In this podcast, we're going to talk about the board and management's responsibilities over environmental social governance, or ESG. We're going to cover a brief history of ESG, how it started and how it's going. And then we'll take a deep dive into some of the things that are on the hot list of topics in the ESG world. We're actually going to take a look at an E, an S, and a G issue. And of course, we're going to be talking about AI since that's what's on everyone's radar screen these days. So to kick it off and to talk about board responsibilities, one of the key questions that board members are thinking about with respect to ESG is how it fits into their responsibilities, and in particular, their fiduciary duties. To give an overview about that, fiduciary duties of board members are to do what's in the best interest of the corporation and its shareholders. There are several components of the fiduciary duties. One is the duty of care, which means to take reasonable care in carrying out your duties as a board member. That means reviewing board materials. That means asking thoughtful questions, engaging in a robust discussion, and seeking out expert advice about questions that are before the board. A subset of the duty of care is the duty of oversight, and this comes out of the Delaware Caremark case. There are essentially two prongs to the duty of oversight. One is that the board has a duty to set up a reporting system to flag risks and concerns. So, in other words, that there is a mechanism in place for issues to be identified and reported up ultimately to the board from the company, employees, and management, so that the board has a way of being aware of what's going on. And then the second prong, which is equally important, is that the board actually has to monitor that system in order to review and consider the issues that are coming up. There's also the duty of loyalty, which is the obligation for board members to act in the best interests of the company and its shareholders and not in their personal best interests. All of these duties come to play in thinking about how boards are managing ESG issues. And we're going to explore all of these as we kind of go into this further in our podcast. But there are also fiduciary duties that apply to management too. Eric, do you want to take that?
Sure. As Terry mentioned, the board is responsible for setting the overall ESG-related strategy for an institution, and also ultimately responsible for establishing an ESG-related risk management framework. Management has significant responsibilities as well. Just speaking in terms of strict corporate governance, generally, management is responsible both for implementing the board's direction and reporting to the board. And in this context, management is responsible for reporting to the board about ESG-related opportunities, risks, providing ESG-related data to the board in order to continuously inform the board about its strategic decisions on ESG-related matters. As I mentioned, this is true of management's role with respect to pretty much all corporate issues, but it's especially important on ESG-related matters. And one reason for that is ESG-related matters permeate into the culture of the entire organization. And culture, of course, is particularly important for governance, since this is one of our main topics here, talking about governance. A strong culture really is a foundation of a strong corporate governance program. So particularly important. Management has a particularly important role on ESG-related governance matters. I think it's worth noting, though, that management's responsibilities, which I just outlined at a high level, they don't stem just from best practices or what the board has put in policies regarding its expectations for management. There are legal responsibilities that certain management has that can come up in the ESG-related context. So, like Terry just mentioned, directors have certain legal obligations, including a duty of care and the related duty of oversight. And recent Delaware case law has held that management has that same duty of oversight. There's a case from last year in 2023 called In re McDonald's, in which the court allowed a claim asserting that a McDonald's chief people officer breached his duty of oversight for failure to properly respond to workplace harassment claims. And the court found that the chief people officer in that case had a duty of oversight similar to a director's duty of oversight. So the obligations on management, again, don't stem just from best practices, but there can be legal obligations there as well.
So turning to ESG and thinking about kind of where it came from and where it's going. In thinking about kind of where it came from, there's some debate about when it started. Some say it was in the mid-2000s. From my perspective, I think it really came into common parlance and jumped onto the national stage back in 2019 with the famous Business Roundtable statement on the purpose of a corporation. The Business Roundtable was chaired at the time by Jamie Dimon, the chair of JP Morgan Chase, and this statement was signed by something like 181 CEOs. And the sea change that this implemented in terms of governance was essentially a pronouncement that the companies were going to be led for the benefit of all of their stakeholders, meaning customers, employees, suppliers, communities, in addition to shareholders. And this was a significant move in governance because essentially it represented a rejection of the shareholder capitalism model that had been the core principle of governance since the early 1970s. And that means the idea that corporations are governed with an idea towards maximizing returns for the company's shareholders only. The movement towards stakeholder capitalism and ESG was amplified in subsequent years, in particular in 2020 by the Black Lives Matter movement, and became a prominent theme in discussions by institutional investors, as well as by other folks in the investment community, including pension funds. But the tide has turned a little bit, and we're now seeing a different wave in an anti-ESG movement.
Yeah, the anti-ESG voices have had their say over the last couple of years. I want to start off by noting what is probably obvious to many, and that is that there's a philosophical dispute over whether ESG-related issues should factor into business decisions and whether ESG-related issues should be the subject of agency regulation. And that dispute, of course, is largely divided along political lines. The anti-ESG movement has been spearheaded over the last several years by governors, state legislatures, attorneys general, and state treasurers, and almost exclusively those individuals in red states. And the anti-ESG movement really became a part of the culture wars over the last couple of years. Anti-ESG statements were made with great fanfare and a lot of political campaigns and editorials. But a number of politicians hit back hard on the ESG movement even after campaign season was over. They took it seriously. And just a very quick recap of some of the highlights, if you will, of that movement. And starting in the summer of 2022, a number of state AGs threatened litigation over what was then the proposed SEC climate disclosure rules. We can fast forward today and we'll talk about this in a second. They certainly carried out that threat, as did a number of other organizations who have sued the SEC over the climate disclosure rules. In the summer of 22, there were also state AG investigations into financial institutions that were members of net zero banking and net zero asset management alliances that had set goals to become net zero by, for example, 2030. And the state attorneys generals started investigations against those financial institutions for allegedly deceptive trade practices, but really in their press conferences spoke in terms or tones of antitrust or anti-competitive behavior or conduct. And there have been a number of other similar investigations against, for example, ratings agencies that some have said have put too much focus on ESG factors in their ratings of companies. Proxy advisors, who, according to some, have been unfairly aggressive in their recommendations about voting thumbs up or thumbs down on directors based on their ESG-related record. And so there've also been a number of other actions in red states where financial institutions who are alleged to or perceived to be boycotting the oil and gas industry or the firearms industry are being prohibited from participating in bond underwritings from managing state pension plans, et cetera. So we've seen quite a pushback. And so I'll turn it over to Arthur at this point. Over the last couple of years, the anti-ESG movement launched a pretty aggressive and multifaceted attack. What's your thought on how impactful that has been?
Yeah, thanks, Eric. And just to add on, we're seeing some of this backlash play out more in courtrooms as well. We'll talk about a couple of those cases later on in the podcast. And just as another example, we're recording this podcast on June 27th. And as we do that, there's an ERISA class action being tried in federal district court in Texas that involves a challenge to a company's pension plans and its investing in ESG-related funds. Just briefly, that class action alleges that the company is mismanaging its pension plans by including funds that are run by investment managers that pursue ESG goals. The class action contends that pursuing ESG policy goals comes at the expense of higher returns available through other investments that focus on generating financial returns. And that's going back to the point Terry made about shareholder capitalism versus stakeholder capitalism. And late last week, the court denied the company's motion for summary judgment. And as I mentioned, the bench trial is underway. So we'll keep an eye out there. And so we have this anti-ESG backlash that's taking various forms: legislation, investigation, boycotts, and litigation. And of course, that backlash was bound to have an impact. And it calls to mind a Wall Street Journal article that summed up one of the primary impacts we're seeing in an article that was published in January with the title, "The Latest Dirty Word in Corporate America, ESG." And the article opens with this line: "Many companies no longer utter these three letters, ESG." And the article cites a study conducted by the advisory forum Teneo that found about 8% of CEOs are ramping down their ESG programs. But that means that the vast majority are staying the course, and they're not abandoning ESG. What the article talks about is the real change is how companies are talking about ESG goals and initiatives. The article notes an analysis conducted by FactSet that found that in the fourth quarter of 2021, 155 companies in the S&P 500 mentioned ESG initiatives in their disclosures. But now compare that to the second quarter of 2023, when ESG was down to 61 mentions. So it's almost a decrease of 100. What the article concludes, and this is something, Terry, Eric, you and I were talking about just last week, is that companies are switching to how they refer to their efforts and using terms like responsible business or sustainability. And we'll continue to see how this plays out around ESG and how things are being reformulated in light of the backlash. So hopefully I think we've set the table. And Terry, with that, maybe I can turn things back to you to kick off our discussion about some governance aspects.
I couldn't agree more about the broader context of all of this. It feels like we'll explore these themes as we talk through some of these very specific points, that the push and pull between the ESG and the anti-ESG movement really says much more about the state of our current politics and the way in which many issues get pulled onto the political battlefield, if you will, that really aren't political. And so as we sort of explore some of these themes, it's worth keeping that in mind and being mindful of Arthur's comment about the fact that while there's a lot of discussion in the media about ESG and pushing back on ESG and sort of stepping away from ESG goals, what we are seeing in many cases is that companies are sticking to their knitting and continuing to focus on ESG, but that isn't getting as much press, or they're simply just going about it and not making so much of a fuss about it. So looking at some specific issues, we're going to start with the E of ESG, and that's in particular focusing on climate disclosure rules. I'm sure everybody's very familiar with the climate disclosure rules that have come out from the SEC, from California, from the EU. And one of the things that's a kind of an interesting complexity for companies operating under multiple regimes is that by having all of these different regulatory requirements that overlap, that may conflict, a company may be subject to different requirements, and navigating those and trying to figure out which ones to apply can be very challenging. It can be challenging, for example, if you're subject to the California rules, which we'll talk about in a moment. You're a public company in the US, so you're also subject to the SEC rules, and you operate in Europe, so you're subject to the EU rules. In that case, you've got potentially 3 different sets of reporting requirements to navigate, and it's obviously challenging to and perhaps even really impractical to prepare multiple different sets of reports. And so what we are starting to see, and we'll be keeping an eye on, is whether what's sometimes referred to as the Brussels effect takes over, which means that the most robust set of reporting or disclosure requirements kind of carries the day, because that's something that a company is obligated to comply with. And it just isn't practical to kind of create multiple different reports for different regimes. So with that in mind, starting with the SEC, the SEC came out with its climate disclosure rules. They were published in 2022. As Eric alluded to, there was quite a lot of discussion about this. I think they received something like 24,000 comment letters, which is pretty remarkable. Took 2 years for the final rules to be adopted. They were adopted in March of 2024. Again, as Eric previewed, the litigation was filed immediately. Interestingly, it was from both sides of this political spectrum. So it was very much expected that there would be litigation from the conservative-leaning states and conservative-leaning activists. But what was perhaps more interesting was that there was also litigation from the Sierra Club and voices on the other side of the political spectrum, taking the position that the SEC hadn't gone far enough. The SEC voluntarily stayed the rules while all of this litigation is pending, and right now those cases have been consolidated in the Eighth Circuit. So, watch the space to see where this all ends up. But to sort of quickly address what's in the SEC rules, the SEC rules, the final rules, require disclosure of climate-related risks that have a material impact on the business. And the materiality is something that came in the final rules, wasn't in the original proposed rules. Businesses are also required to report any climate-related targets or goals that have materially affected or are reasonably likely to materially affect their business. They're required to report Scope 1 and 2 emissions. Scope 3 emissions were included in the original proposed rules, but omitted from the final rules. And just quickly to set the table about what that is, Scope 1, direct emissions by an organization, meaning like emissions from a company's factories or its own vehicle fleet. Scope 2 is indirect emissions related to a company's business, but kind of under the company's control, for example, like emissions associated with the energy that powers a company's facilities, for example. And then scope 3 is sort of a further removed category, emissions from the company's value or supply chain. So, for example, like emissions from trucks that are owned by suppliers that are delivering commodities to the company's facilities, that's in the scope 3 bucket. In the discussions and in the comments around the SEC rule, there was a lot of objection to the inclusion of scope 3 rules, and they were not included. But, preview, they are included under the California rules and in the EU rules. So companies that operate, that are subject to the California rules and or EU are going to have to be tracking those anyway. Another couple elements in the SEC rules requires disclosure about the oversight by the board and the role of management in assessing material climate-related risks, company strategies, plans, and activities to mitigate or adapt to the material climate-related risks. All of this plays out for public companies in terms of required reporting in their periodic reports, meaning 10Ks, 10Qs, and 8Ks. So given that we're in the midst of this ongoing litigation and the voluntary stay is in place, it leaves corporations somewhat in a quandary about whether they should start tracking and disclosing this data. But again, this sort of transitions to the question of what other regulatory regimes are they subject to? Are they under California or the EU? California, in this past year, adopted robust climate-related disclosure rules that apply to corporations that do business in California, and that's very broadly defined. And then there are revenue thresholds, so corporations with annual revenue that exceeds, in one case, $500 million with respect to the financial risk disclosure laws, and then $1 billion in annual revenue with respect to the Corporate Data Accountability Act, which is a required report on scope 1, 2, and 3 emissions. Those are both ongoing requirements. There has been litigation in California, but there has not been a stay. So the California requirements are in place. Regulations are being developed to implement the California rules, and those are a necessary part. That is in process, and we're all watching to see kind of what those regulations are going to look like. I want to underscore one important piece of the California rules also, which is the requirement that it's under AB 1305, and that if a company is making net zero claims, which is not uncommon, that a company then has to essentially explain how those net zero goals are being met, assessing progress towards the net zero goals, whether they're seeking independent validation, and then importantly, additional disclosure requirements related to carbon offsets and to the extent that a company is relying on carbon offsets. So it's a complex web of different kinds of reporting requirements that a company is subject to. And the EU which has its own complicated set of disclosure requirements as well under CSRD and CSDDD. So for companies having operations in multiple different places, it's going to be an exercise in navigating all of the disclosure requirements and figuring out which ones are going to be applicable to them and how to manage putting out a single report, which is probably going to be the easiest thing to do, that complies with the most robust of those requirements. Eric, I know you had some thoughts on this. Do you want to share?
Sure. That was an excellent recap, Terry. Thank you very much. I would say the one thing to keep in mind is that even though we are in this holding pattern right now with respect to the SEC's climate-related disclosure rule, to keep in mind that you can still get in trouble with the SEC if you make a material misstatement or omission, including about climate-related risk or other ESG-related topics. So do not fall into this complacency or get a false sense of security that just because the SEC climate-related disclosure rule is temporarily stayed, that you don't need to be careful about your climate-related statements. The SEC can always initiate and take an enforcement action against any company that makes any materially misleading statement, even if it is ESG-related. The SEC has an ESG task force. So there is a small army of enforcement attorneys who are looking for something to do, and they are investigating material misstatements and omissions in the ESG context, even though the SEC's rule is temporarily on ice. So just a warning to not fall into this false sense of security while the rule is tied up in litigation.
That's a really important point, Eric. And I think it's worth noting too, because to the extent that a company is putting disclosures in its voluntary ESG reports or is including information in the reports that it is preparing and filing under the California or the EU regimes, all of those things are public disclosures and potentially subject to, Rule 10b-5, which is the rule about material misstatements or omissions. Arthur, I bet you have some thoughts on this. Do you want to contribute?
I think that's exactly right. There are some common core principles of SEC enforcement that really don't vary across the subject matter that are still in play. And so, like Eric and Terry, you've been saying, the rule may be on hold for the time being, but you still need to be careful. And I think we'll come back and talk a little bit more about just controls as a way to have good governance.
Exactly. Well, with that, we've covered an E issue. Now we'll turn to an S issue, and we're going to talk about the ongoing discussions and some recent case law relating to DEI initiatives by corporations. And Arthur, I know you have some thoughts to share on this.
Yeah, thanks, Terry. And you're exactly right. We can draw straight from recent headlines. There is an 11th Circuit decision from earlier in June that granted a preliminary injunction preventing a venture capital sponsored fund. It's named the Fearless Fund from administering a program that would have awarded $20,000 grants to small businesses owned by Black women. The 11th Circuit ruled in a 2-1 decision that the Fearless Fund's grant program is substantially likely to violate Section 1981, the Civil Rights Act, which prohibits race discrimination in making and enforcing private contracts. There are a number of points that the decision goes through, which our Arnold and Porter colleagues have analyzed in an advisory available on our website. I'll just touch briefly on a couple of the aspects here. The first is the initial issue addressed by the court, and that's whether the challenger, the American Alliance for Equal Rights, an organization that has pursued a number of challenges to DEI initiatives, had institutional standing to sue the Fearless Fund. The majority found that it did because, among other reasons, it offered declarations from anonymous members asserting that they would have qualified for the grants, but for their race. And they also specified how they would have used the $28,000 grants if they had received them. Now, the dissent disagreed with the majority, focusing on the issue of standing, but without reaching the other issues. In the dissent's view, the declarations that the Alliance's members provided were boilerplate generalizations, amounting to faking an injury. The dissent uses a pretty vivid comparison, and it analogizes the challenge to flopping in soccer, manufacturing a foul that a player hasn't actually experienced to manipulate the referee into awarding a penalty kick. Very much an issue that we're going to keep an eye on, in part because both the Fearless Fund and the dissent point out that the Second Circuit Court of Appeals has come out differently than the 11th Circuit majority in another case. In that other case, a do no harm case, the Second Circuit found that a challenge to a diversity fellowship program was okay, or at least there wasn't standing to challenge it, because the organization that brought the challenge failed to identify members by name that were challenging it and failed to signal a concrete readiness to apply the fellowship. So we'll keep an eye on the development of standing law there. There's also the issue of whether the grant program violated Section 1981. The majority found that it did because while Section 1981 recognizes a valid remedial program exception, in some instances, it wasn't applicable here. Just to step back for a moment, courts recognize that in discrimination cases, Title VII, employment litigation, a race-conscious remedial program does not violate anti-discrimination laws if it addresses, quote, manifest racial imbalances, unquote, and does not unnecessarily trammel the rights of others or create, quote, an absolute bar to the advancement of other people, end quote. And for perspective, research shows that less than 1% of venture capital goes to businesses owned by Black and Hispanic women. And so there may be a valid remedial purpose, but the majority found that the contest did not qualify because it nevertheless unquestionably creates an absolute bar to the advancement of non-Black business owners. And because the grant program's rules expressly limited acceptance to Black females, the majority found that the contest employed an impermissible categorical bar on non-Black applicants. There's also an issue about whether the First Amendment provides a defense, but the majority rejected that as well. According to the majority, the Fearless Fund grant program constituted an act of discrimination and was not expressive speech protected by the First Amendment because the fund simply refuses to entertain applications from business owners who aren't Black females. So it's worth keeping an eye on how this unfolds. The Fearless Fund has until July 24th to petition the 11th Circuit for rehearing or rehearing en banc, or it may file a cert petition. We'll see. It is worth emphasizing that the Fearless Fund involved a challenge to a grant program that was expressly limited by its terms to Black women. It's a little bit unsettled about whether a program that considers race among other factors and does not in any other way impose a categorical race requirement could be a valid remedial program subject or exempt from liability under Section 1981. So we'll all keep an eye out on that and further developments on the Fearless Fund case.
Wow, that's fascinating. You mentioned the July 24th date for what Fearless Fund will do next and possibility of a cert petition. It sounds like there's a split in the circuit. So is it reasonable to think that the Supreme Court might potentially take this up?
I think that's right. We're definitely keeping an eye on it. And, the issue of institutional standing, given the Second Circuit coming out the other way, could very well be an issue the court takes up.
Wow. Something that for us all to watch for the Supreme Court's next term, I presume. The other sort of new issue that we wanted to focus on is, I think, in the G space with respect to shareholder proposals. And this is a case involving litigation over a shareholder proposal put forth by Arjuna Capital against the company, against Exxon. Arthur, I know you've been following this closely. Do you want to tell us about kind of what the context is here?
Yeah, thanks, Terry. Let me set the table on this one. It's an interesting case with a couple of layers to it. In January 2024, Exxon filed a lawsuit against two shareholders seeking a declaration that it could exclude those shareholders' proposal from the company's proxy statement under Rule 14A8 of the Securities Exchange Act. The shareholders, Arjuna Capital and Follow This, had submitted a proposal regarding reducing the company's greenhouse gas emissions. One interesting aspect of these cases is that the shareholders told the company that it was withdrawing their proposals after the lawsuit was filed, seemingly making the case moot. But the company continued with its lawsuit anyway, arguing that there was still a live dispute because the shareholders might renew their proposals. And to support this point, the company alleged that Arjuna and Follow This are not like ordinary shareholders who invest in the interest of obtaining a return on their investment. Instead, the company argued that those shareholders pursue what they call a Goldilocks Trojan horse strategy, where they become shareholders solely to campaign for shareholder proposals that would actually diminish the company's business. As the litigation unfolded, the federal district court in Texas dismissed Follow This on personal jurisdiction grounds. Follow This is an organization based in Netherlands, so that's no surprise. But the court allowed the case to continue for a while longer against the other organization, Arjuna. I say a while longer because Arjuna just recently reiterated to the company that it was withdrawing its proposal, and in its last try, it said explicitly it was unconditionally and irrevocably covenanting not to submit a climate change proposal for consideration by the company's shareholders. It was with those magic words that the court ultimately agreed to dismiss the action as moot. Maybe one other interesting layer to the case. Both Exxon and the court were somewhat critical of the SEC for what they perceive as a failure to enforce Rule 14A8, which would allow for the exclusion of shareholder proposals in certain circumstances. The company's complaint is pretty explicit on this point. It alleges, for example, that a similar proposal had been rejected by close to 90% of the company's shareholders during the 2023 proxy season, as well as a similar rejection in the 2022 proxy season. And that under the plain language of Rule 14A8, the company should have been able to exclude the shareholders' proposal. The complaint alleged, however, that current guidance by SEC staff about how to apply the rule can be at odds with the rule itself. Even though that guidance has no legal force or effect, defendants or other similar activist organizations rely on it, to pursue their personal preferences at the expense of shareholders. In its order dismissing the company's complaint as moot, the court recognized this backdrop, and it noted that the company could very well be using the lawsuit as a, quote, proxy for a battle with the SEC, unquote. And the court added, the SEC is behind the ball on this issue. Nevertheless, because the action is now rendered moot, the court did not have an occasion to reach Rule 14A's A8's scope, and we shall see if there's further developments in that area in the forthcoming litigation.
This is such a really interesting case for the reason that, as you note, Arthur, it was kind of thought of and in fact written about as being a proxy for raising a real concern with the SEC's proxy rules and the way that they're being administered. And I think it's also notable too that the issues raised in this case around this Goldilocks Trojan horse, which certainly creates an interesting image for all of us. The idea that activists are using the shareholder proposal process for political purposes. I mean, this came up in the context of Arjuna and Follow This, who are advocating to limit emissions. They're coming at this from the liberal side of things, but it could just as equally have been coming up with respect to a shareholder proposal propounded by conservative activists, advocating raising a proposal for something different. In the same context, this question around, is this the right use of the shareholder proposal process, could come up for, on whichever side of the spectrum, you fall on. And I think it raises some interesting philosophical questions for all of us in the governance space and for the SEC to consider as to what really is the fundamental purpose, and should there be some more governors around the shareholder proposal process so that it really does focus on the company at issue and the people who have invested in the company because they think it's a good investment and they expect that it's going to prove to be valuable in the long term, versus activists who have invested in the company perhaps arguably for the sole purpose of raising these issues. So I think, again, it just illustrates how politicized the governance world and the ESG world has become, that even things that many years ago would have been thought about as a purely corporate and kind of relatively non-political issue are coming into the political arena. So we mentioned at the top of this that we would be talking about ESG and AI, and of course AI is one of the issues that's at the top of the list for every company right now. Boards are certainly thinking hard about how AI is going to affect a company's business, how AI can affect the way that they operate in the boardroom. And one of the things we wanted to touch on here was the overlap and the intersection between AI and ESG issues. In thinking about it, there's sort of almost look at this as like a pro and a con. So with that framework, I'll take the pro side, which is that you could look at it and focus on the fact that AI can provide very useful tools for companies in managing their ESG goals, in analyzing data, in identifying opportunities to reduce emissions. For example, on the climate side, it provides a wealth of different ways in which a company can take advantage of the incredible processing strength of AI tools to further ESG goals, to test theories, to kick the tires, et cetera. But there are also complications, and I think it's worth thinking about the other side of that and ways in which AI may kind of cut the other way. And Eric, I know you've been wanting to speak about this. Tell us what you think.
Sure. Thanks, Terry. So you just mentioned the use of AI for managing ESG goals, and ESG goals are largely concerned with the individual and improving employees' work experience and the work atmosphere for the employees. But the ironic thing is that there's a very real potential that AI will eliminate a very large number of employee positions, of jobs. There's a study out by the OECD that found that 27% of jobs are in occupations that are at high risk for automation. So that's one overarching con, I would say, with AI in the ESG context. But a couple of other areas to think about where there may be some potentially detrimental impacts of AI to ESG-related goals and initiatives if they're not thought about carefully. One is that AI has a very significant impact on the environment. The use of AI systems is massively energy intensive and therefore carbon intensive. Data facilities that store and manage IT systems, including AI systems, are responsible by some estimates for 2 to 3% of the global greenhouse gas emissions. And that volume of data that is being stored in these data facilities, largely, again, for use in AI, by some estimates is doubling every 2 years. So the carbon emission problem that corresponds with the use of AI is exponentially increasing. Another issue is privacy. AI requires a very large amount of data to learn. It takes in data, processes data, analyzes it so that it can then perform its functions and engage in decision making. And with that collection of a massive amount of data comes very significant privacy concerns. What data exactly is being collected? Is it personal data? Is it my PII? Where is it being stored? What type of security and safeguards are around the storage of my PII? Is that system vulnerable to hacking, et cetera? Another concern is the potential bias in data that is being fed into AI systems. So data can be very factual. However, even purely factual data can lead to disparate impacts on protected classes, in which case there could be illegal results that flow from the use of AI data without thinking about that disparate impact. Let me give you an example. In credit underwriting, many banks use AI to collect information about borrowers and to help the decision on whether to extend a mortgage or not. But that data that they're collecting and using to make that mortgage origination decision could result in a disparate impact where minority borrowers are receiving fewer mortgage originations, and the bank could be putting itself in a position of potentially violating fair lending laws and other consumer protection laws. This also happens, taking it out of the financial institution context, but more generally, this can also be a problem with HR departments. And a lot of large companies are starting to use AI to do an initial screening of employee applications. And if that's not done carefully, there could be disparate impacts involved in companies using AI to make that first cut of people to bring in an interview. So I don't want to then say, okay, well, let's abandon AI. Obviously, that's not going to happen. That's not the direction the world is going in. So what are some things to think about to use AI safely and smartly? Think about, for your company, the extent that you are going to allow AI to replace human jobs. That's a tough decision, but it is a decision that a lot of companies are going to have to face, and you should start thinking about that decision now. We could talk forever about all that goes into that, but it's something that needs to be thought of. But not to be so dour about it, think about it also in a positive way about how this may create new jobs. So for example, going back to that credit underwriting example, could be that you are replacing a team. Well, I shouldn't say replacing, but moving a team of people who are doing manual data entry for the credit underwriting process, for example, or tracking loans, and moving them from that very data entry type job, replacing their job with AI, but maybe retraining them to do something like go out and originate more loans. And so thinking about how to shift people's responsibilities. Another thing to think about is transparency. What is a common concern is that data gets fed into a system, and it then the system becomes a black box, and nobody at the company can really explain to anyone, including the government, how decisions are being made in that AI system. That's not a good situation to be in, because if you're ever in trouble or ever in the position where you have to answer questions from your regulators or DOJ, for example, the answer, I don't know, we just turned on the AI system and it spit out some decisions that may have violated fair lending laws, for example. That's not a good answer. You need to have an actual human being who can understand exactly the data that goes in and how decisions are being made through that AI system. One other point, talking about the human involvement in AI is having oversight over the AI development team, making sure that the people at your company who are responsible for developing and growing AI systems are being governed by well-defined policies, procedures, ensuring that somebody is monitoring their work. They may have biases that are totally implicit biases, not even like being saying anything critical, but we're all human and we all have biases whether we know it or not, but ensuring that their biases aren't infecting the data or the data output that goes through the AI system. So some things to think about as AI just becomes more and more part of our daily work lives.
Well, and bringing it back to one of the points we started with, looking at the board's role and thinking about the board's duty of oversight, this is a great example of a way in which this gets played out in real life, and that at this point, boards are thinking about how AI is going to be used in the company's business and should be structuring those reporting up structures to address these kinds of questions that Eric is raising. How is AI being used? Is it being implemented in a way that is going to identify and mitigate endemic bias? How are the effects on the company's workforce being addressed? Is this consistent with the company's values? All of those things build into what the board is going to be doing, and many boards are making AI a regular part of their board agendas and having management report on the impacts of AI in the business at each board meeting. Arthur, you look like you want to share some thoughts on this too.
I was just going to add one other point, and we know regulators are paying attention too. So just like AI is important to boards, the SEC, for example, has expressed a very keen interest in making sure that disclosures are appropriate too. And while this isn't necessarily specific to ESG, one example that comes to mind is a speech SEC Chair Gary Gensler made relatively recently, in which he warned against what he calls AI washing, making false or unfounded AI-related claims. And of course, he used that verbiage to liken to the practice of greenwashing, which has already been the target of an SEC crackdown, and it has ESG roots. And so, just for our listeners, hopefully to bear in mind, it's not just how you operationalize it within the company, but also how you report out and your disclosures.
An excellent point and a great way to sort of wrap this up. So as we conclude here, let's do a quick lightning round of just a couple quick takeaways for our audience to note. So Eric, why don't we start with you? Anything you want to leave folks with on ESG?
Yeah, sure. My one takeaway would be don't be bullied into abandoning your corporate principles. The ESG versus anti-ESG movement has been combative. There are a lot of companies and individuals who are going through tough news cycles. There are a lot of high-profile, uncomfortable hearings that are being held in Congress. There are government investigations. There are litigations. But the thing to keep in mind is that politicians come and go. Popular sentiment shifts rapidly, but that's not true of principles, even corporate principles. So what I would recommend and what we do advise our clients to do is to wait out the storm a little bit, maybe keeping your head below the parapet a little bit, but not jumping overboard either. Be smart and be resolute, but don't abandon those principles.
Great points. Arthur?
Yeah, I think I agree with all of that. And I'd also add, just to reiterate a theme we've been talking about, process matters. So it's important to have a system of internal controls that will help navigate through some of these issues, especially as you get push and pull from both directions. And our board and our officers are kind of in the middle. They need a framework to kind of navigate that. And it's important to have a process and controls that'll help them do that.
Couldn't agree more with both of those. And the last thing I'll note is simply that from a board standpoint, and coming back to fiduciary duty, the fiduciary duty of a board do what's in the best interest of a company and its shareholders can be looked at on a long-term basis. And so when you're thinking about issues around ESG and how to build that into a company's plans and strategies, it's entirely appropriate, and to the extent it's consistent with the company's values, be looking at it on a long-term basis and to be thinking about the long-term effects on the climate, on society, on the company's various stakeholders. So worth keeping in mind as companies, directors, management navigate through the process of making decisions around ESG. Thank you all so much.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.